go this way. Okay. So I just want to touch on a couple of things that I think maybe some of the Russians that I've worked with have not been familiar with. And one is the incredible cost of litigation in the West. And it's not just the United States. In fact, I think it's more expensive to pay for lawyers in court in the UK or in the Netherlands, which people mentioned earlier today. And the French lawyers are certainly very expensive. Most of the time in litigations that I'm involved with, the cost of paying for the litigation or the cost of defending yourself is so substantial that it just is impossible for anybody to contemplate sticking it out in the litigation. So most of the time, that's why it gets settled. We've talked a lot about licensing intellectual property and not transferring ownership, and I'm going to give an example or two of why that's a problem in many of the legal systems here. I also have found that it's amazing how many times people sign contracts and they don't understand the royalty provision. And at some point in time, I'm not going to say every publisher, but a lot of publishers don't pay or submit royalty reports that are very hard to figure out, or submit royalty reports that clearly make no sense. And you see this not just in the video game world, but Hollywood accounting is famous for this. And so it's very important to figure it out and come up with a very simple way, I'll discuss that you know the basis on which you're going to get royalties paid to you or that you're going to pay royalties. And the other thing I've been sort of shocked about in some cases is how often people don't maintain their email correspondence or their milestone builds that they submit, or even their final archives, and very shortly after you get paid something, a dispute arises, and I'll turn to my client and say, okay, let me see the build that you submitted, and say, we don't have it anymore. So I'm going to discuss those four things very briefly today. I mentioned the costs of litigation in the Western system can be overwhelming. And I'm going to give you an example of something that occurred in one of your colleagues here. They hired an artist, and they said they wanted a particular type of character to appear in a game. And they described what the character was going to look like. And the artist signed a piece of paper saying, I will prepare something that is unique and original, and I'll give you the copyright. So they loved this particular character, and they not only put the character, my client, in the game, but they also put the character on the box, and they also put the character on the side of the stand-up that was in, let's say, Walmart, which was what they used to sell the game. And they put many millions of dollars into marketing the game. And about 2 days after the game came out, the person whose picture was on the side of the box in Walmart and on every game contacted us to say that his image had been completely copied, and in fact it was true. The artist working in one of the studios here had gone online, had found somebody he thought was cool, and had actually exactly copied it, okay? This was something that the developer and publisher had no idea of, Walmart had no idea of it, and I'll show you the email that I got from the representative of the person whose image had been copied. Email number 1 says, and he was probably right, it's going to cost you $150,000 minimum just to pay the cost of defending this case, because this was clearly a breach of copyright law. So what were we going to do? Recall all of the games? And then he got more aggressive, and he started talking about bringing criminal charges, et cetera, et cetera. And I had to tell my client that it's going to cost $100,000 perhaps to litigate this thing, maybe more. And even if they were innocent, they had responsibility for the person that worked for them. So, of course, we had to settle that case, and we had to pay quite a bit more for the right to use that image that we would have paid if we had just gone ahead of time and done that. So even though you do everything right and you tell everybody in your studio not to copy anything and they sign it, etc., sometimes it's not going to happen. Okay, so let me suggest an alternative here to prepare for defending these types of cases would be to get yourself what's called errors and omission insurance. If you're going to do business in the West, we're so litigious and it's so much different from the Russian system. You need to get some kind of an insurance policy, and if you do get that insurance policy and you have made a mistake or somebody working for you has made a mistake, the insurance company is not only going to pay whatever it takes to deal with the person that you've done wrong, even if it's negligence, but they're also going to pay all the costs of defending you. So in the case that I just described to you, had there been insurance, the insurance company would have paid the $100,000 for the lawyers to defend the case and would have settled the case. Not only do they pay to settle, but they have the duty to defend you. That's a piece of the world in the United States, doing business in the United States, that I would pass on to you. And I will just mention that a Russian company cannot buy this type of business insurance in the United States. You need to have an office in the United States. And I think almost all of the Russian clients or Eastern European, Ukrainian clients that I've worked with have either British Virgin Island or Cyprus or some other type of offshore entity. And what I'm suggesting is that you might want to consider, if you're coming into the United States, having that offshore entity have a subsidiary, which is a U.S. subsidiary, and setting up a company in the United States and doing business through that company in the United States and using that company to buy the type of errors and omission liability insurance that I'm talking about. And you'll see that you can set up a U.S. company for $1,000 or $1,500. It costs you $1,000 a year, including your accountants to file your tax returns. And you can buy an insurance policy for $1,000, $2,000, $3,000, $4,000 that'll provide you coverage. Now that is, I think, a good, solid way to prepare for the risk of what I've had, 3, 4 different Russian companies that have been sued in the United States, sometimes frivolously. There's no basis to the lawsuit, but once you're sued and you find out how much it's going to cost to defend yourself, you have a big problem. So I just wanted to take a chance to pass that on. As I mentioned, in the UK, it's even more expensive. In the UK, the lawyers that I'm typically working with, they're charging $800, $900 an hour. I want to mention one other thing, and I didn't realize that we were going to have so much discussion on assigning your IP or licensing it or acquiring it, etc. But once you have assigned or transferred your IP, or as Sergey said, agreed to do something as a work for hire, the intellectual property is owned by the publisher or the financier who owns it. And oftentimes, even if they breach their contract with you and you've assigned the IP to them and they don't pay you, you're only able to get damages. You're not able to get the intellectual property back. And you also may find yourself in a place where you have assigned your IP for a game that you created, as Sergey recommended, and next thing you know, you want to do the sequel, and you find out that you can't do the sequel because it's derivative of the first game, and you're in a dispute with people that own the first game because they haven't paid you for it, but they still control the rights. So